Hello, everybody. Welcome to this week's lecture. We are going to be examining rights-based frameworks and free, prior, and informed consent. Now, these are not technical procedures, but contested political demands about who holds authority over land, resources, and futures. So you can see how this connects pretty well to, our issues of conservation, environmental governance, but especially environmental justice. We're going to analyze both these frameworks' potential and some significant limitations. Okay. So by the end of this session, you should be able to analyze rights based frameworks as legal instruments that operate within specific power structures. You will be able to deconstruct FPICs, their theoretical foundations, examine the substantial gaps between principles and practice. We're also going to evaluate the effectiveness, go over some case studies, and talk about different context and consider critiques that question whether consent based approaches can function within fundamentally unequal systems. Okay. So we've talked about environmental harms, we've talked about some fortress conservation and some structural and slow violence. Now we're kind of talking about the mechanisms, right? Some of the legal and political frameworks. FPIC is going to be a really commonly used framework and tool within the conservation and environmental governance space. Okay. So let's dive into that, right? Rights-based frameworks, they have a specific genealogy, right? They emerged from those critiques of fortress conservation in the 1980s and 1990s that we talked about previously. The Yellowstone model is, the preeminent example, as we mentioned, created in 1872. And this established that template, right? Remove people, create pristine wilderness, and allow tourist access, generate that income, right? And this model, it was exported globally. And this resulted in what Brockington, that ego document that we mentioned in that last week, 14 to 15 million people displaced by protected areas worldwide, right? Rights-based frameworks emerged as a response to these mass displacements. Rights-based frameworks attempt to integrate human rights law with environmental governance. And this is going to be critical to thinking about how environmental justice concerns manifest, structure, and are mitigated, right? So the shift was from treating communities as sole beneficiaries of conservation or environmental benefits to recognizing these individuals as rights holders with decision-making authority. However, tensions they persist between collective indigenous rights and state claims to territorial sovereignty that we're going to go into that make these things quite complicated. So, what is FPIC? FPIC stands for free, prior, I spelled prior wrong there, free, prior, and informed consent. Okay. This requires definitional precision because each word carries specific legal and political weight. Okay. Free means the absence of coercion, intimidation, manipulation, or conditional threats. This is rarely achieved when development projects are tied to national economic strategies, and examples like refusing means being labeled anti-development. Okay. Prior means consultation must occur before project authorization. That's critical. And there must be adequate time for communities to deliberate using their own decision-making processes. Okay. In practice, consultations frequently occur after project design is finalized, making this prior meaningless, right? We're kind of just going through a performative activity. We're checking boxes at that point. Informed means complete information about the scope, duration, reversibility, which is key, environmental and cultural impacts, and benefit sharing arrangements of the proposed project or proposal. This must be provided in accessible formats and languages, right? That's key. Consent means that the communities have decision-making authority aligned with their customary governance structures, right? It fits within locally, culturally, indigenously appropriate governance structures. This is not just consultation, okay? That is just, sort of implies input. This is not just participation, right? Which that implies involvement. This is consent, which means there is veto power, okay? There is the ability for these individuals to say, nope, we don't approve this. We're not going to let this go forward as planned, right? And a lot of legal systems, and we've seen this throughout the environmental justice movement, dilute this to meaning an idea of meaningful consultation, right? But the veto is removed, right? And this is just the reality across the board. It's really hard to get a developer to agree to the fact that you might be proposing a project to a community and the community might vote it down, right? But that is critical if we're actually practicing real FPIC, okay? Now, the legal architecture of PIC, it's a lot here. We can't get into all this in depth, but it really spans international and national frameworks. So, the UN Declaration on the Rights of Indigenous Peoples, adopted in 2007, with 144 states affirming. This includes FPIC in Articles 10, 19, 29, and 32. You don't need to know all that. But the ILO Convention 169, adopted in 1989, has been ratified by only 24 countries, notably the United States, Australia, and Canada, until recently refused to ratify that. And this really shows that how even wealthy democracies, they resist when indigenous rights conflict with resource extraction. This week, we're also going to talk about resource curse, neoliberal policies. This resource extraction is where people tend to disappear this FPIC concept. The biodiversity, or the Convention on Biological Diversity, it includes FPIC in the Aichi Target 18 and now the Kunming Montreal Target 2022. And then you also have regional instruments. So you have the African Commission on Human and People's Rights and the Inter-American Court of Human Rights. They have developed FPIC jurisprudence. You also have the national implementation varies dramatically. You have this as a reality, like the Philippines Indigenous Peoples and Rights Act in 1997, Bolivia's 2009 Constitution, which provides rights to nature and indigenous communities, and in Indonesia's 2012 Constitutional Court ruling, which recognizes traditional forests all bearing and must include FPIC within their jurisdiction. But with this different enforcement mechanisms and very different structures, globally, national, regionally, you see practical limitations, okay? So a lot of data has been collected, and this, the success of FPIC has been studied, pretty well. And a lot of implementation data reveals a lot of systematic failure, right? The World Bank, which again is not like the we should be careful again who's collecting the data. But anyway, the World Bank's inspection panel found that between 2015 and 2020, 68% of projects failed to comply with safeguard policies. 68%, right? Oxfam's 2014 analysis showed fewer than 30% of REDD+. Remember, REDD+ is this carbon capture program we see within forest governance and climate action. We're going to dive into that more this week. Fewer than 30% of REDD+ projects designed to incentivize forest conservation demonstrated meaningful FPIC. And the Forest Peoples Program documented that consent is frequently reinterpreted as do no harm, right? Consultation, removing decision-making authority. This is not so good, right? And these definitions can vary widely. And timeline manipulation was also noted as common, right? Consultations are conducted after project designs are finalized. This is a very serious trend, and I've seen it personally in my work many, many times. And again, this makes community input cosmetic rather than substantive, right? And this is kind of the norm that you see across the environmental space. And these are not, random implementation failures. These are patterns, like I said, that reflect institutional priorities where, development speed and cost are many times going to override rights protection. A really good example is the Barro Blanco Dam in Panama, right? So the Barro Blanco Dam, it really illustrates how FPIC can be systematically circumvented. So this 28.84 megawatt hydroelectric project on the Tapasara River was constructed between 2011 and 2016 in Ngame-Bule territory, indigenous community territory. Panama ratified that ILO convention that we just talked about in 1995, and this created that legal FPIC obligation. But the government claimed that consultation occurred. The Ngame-Bule community documented their exclusion from decision-making and opposition to the project, and the Inter-American Commission on Human Rights issued precautionary measures in 2015 calling for construction to stop, right? The dam was completed anyway. And this case really demonstrates that legal frameworks without enforcement mechanisms, which is so much of our lived reality and the structures we operate within, especially at a global and national level, they're going to fail if they don't have that enforcement mechanism. It really raises the question, under what conditions, is FPIC respected versus ignored? What do you think about that, right? Take a moment to think about that. Prey Lang in Cambodia, an area I've actually been and have a lot of familiarity with. This shows a different pattern, right? So, research from this region documents that community-led enforcement, when state mechanisms fail, is a really effective tool for FPIC. So, this 431,000 hectare forest, they faced a lot of logging concession concerns. So a lot of areas were being sold either legally or illegally for logging. And these concessions were granted throughout the early 2000s all the way through 2020. So the indigenous community in this region established monitoring networks and they conducted their own patrols documenting violations. And the government was shown to have granted concessions for these logging operations without FPIC. So the community filed a complaint under the Convention on Biological Diversity in 2019, and this case really illustrates how communities can often enforce these FPIC principles themselves when the states fail to do so, right? But the effectiveness is limited by, the substantial risk that communities bear and the resources they require for this continuous monitoring, right? It's a lot. And this really shows the burden of proof and enforcement falls on those least able to bear it, which is going to be a theme we're going to explore deeper. So conservation, environmental work, and FPIC, they occupy contested terrains, okay? Fortress conservation, as we mentioned, displaced 14 to 15 million people globally. And IUCN Category 2 protected areas, which include national parks, these were often established without consent or recognition of existing communities, right? The paper parks phenomenon. This describes protected areas designated without management capacity or community buy-in, okay? This often creates conservation on paper, as it says, while actually doing little for biodiversity or improving the situation within the local ecosystem. Current commitments, as you know, we've talked about, but you might be familiar with the media, to protect 30% of land and sea by 2030. This creates a lot of fear about repeating these displacement patterns. And the Rights and Resources Initiative found that only 10% of protected areas formally recognize Indigenous land tenure. That means that 90% have these ambiguous or hostile relationships with local people, these protected areas. Again, this creates fundamental tensions between conservation objectives and rights-based approaches. And Indigenous scholars, they've offered many critiques and documented some of these violations. So, Glenn Coulthard from Yellowknives Dean Nation argues in Redskin, White Masks that recognition politics can reinforce colonial state authority rather than challenge it, right? So we see recognitional justice quite clear here. Seeking recognition from the state positions that state as the legitimate grantor of rights. Do you see how that power structure is reinforcing itself? Audra Simpson, a Mohawk scholar, develops the concept of refusal in Mohawk Interrupt Us. And Audra suggests that saying no is a political act asserting sovereignty, not merely exercising a right granted by others. It's quite powerful. Eve Tuck and Kay Wayne Yang argue in Decolonization is Not a Metaphor that some colonial structures require dismantling, right? Not negotiation through consent frameworks. Leanne Bedasamosake Simpson from Michi-Sagig Nishnabeg Nation, I probably did not do that justice, I apologize, advocates for resurgence over recognition, right? Focusing on rebuilding Indigenous political and cultural practices rather than seeking state acknowledgement, right? This kind of connects to some ideas of land back, right? Ceding land back to Indigenous communities, ceding control over national park land back to the original stewards. These critiques really, should be engaged seriously. They suggest that FPIC, while, valuable and an important tool, it may not address the fundamental power imbalances that it claims quite strongly to remedy. Okay. And again, we're back at power too, right? Power asymmetries are prevalent here, and they're going to manifest in specific documentable ways during FPIC processes. Now, you have tons of practice documenting power structures, but one really serious way is going to be this idea of information asymmetry, which is structural and procedural, as we talked about. Environmental impact assessments, they run hundreds of pages with technical terminology, and translation to local languages is often literal rather than conceptual, and this makes documents incomprehensible, sometimes even when linguistically accessible. I have to think about that, right? Economic pressure frames development as the only path out of poverty. This is so common, making refusal appear irrational, right? And can really be used to devalue and denigrate people fighting for their own sovereignty and rights. Time constraints are often used strategically, right? So consultations can be scheduled over really short periods of time, over harvesting seasons, over ceremonial periods, or, with inadequate time for any sort of actual internal deliberation, right? You see this sometimes with, government programs or open forums that will have like a comment period of just a couple days, right? Not nearly enough to actually get meaningful civil input in FPIC. And also, divided communities that result from corporate sponsored civil society organizations, this can create manufactured consent. I mean, think like large scale mining operations or large scale extractive groups like oil and gas. Gendered exclusion occurs very prevalently within this when consultation forums are going to privilege like male elders while excluding women who may have different interests and knowledge. Legal pluralism is going to create conflicts when customary law governing land tenure is going to contradict with state legal frameworks. And again, it's important to consider these are not implementation flaws, right? But they are often features, not bugs, right? They are purposely built in sometimes to advantage project proponents, and we have seen this throughout history. So we're going to talk about just transition, moving into some content in the future. So I'm not going to go too far in depth, but I want you to keep this in mind that, green transition, it creates new FPIC challenges that risk replicating these same extractive patterns under environmental justice concerns and environmental justification, right? Lithium extraction for electric vehicles, this also displaces indigenous communities in the Argentine Puna and Atacama Desert. Gunare in 2022 documented this. Norway's Supreme Court ruled in 2021 that Fosen wind farms violated the Sami reindeer herding rights, yet the turbines, they continue operating pending appeals. So this shows that even favorable court decisions, they don't guarantee remedy, and often sometimes these proposed green projects, they can create their own negative externalities, okay? Just kind of setting the stage for us to think about this a little bit more as we go in. Let me search my notes a little bit more here to see what else. But again, FPIC, as we opened with, that it's not a panacea, right? Some jurisdictions have moved beyond this standard FPIC toward co-governance models. Hawaii, Guay in British Columbia, or sorry, Haida Gwaii in British Columbia operates under shared decision-making between Haida Nation and the provincial governments. And in this situation, both parties hold veto power. The Great Bear Rainforest Agreement similarly establishes this, where collaborative management is critical and veto power is shared. Indigenous protected and conserved areas in Australia and Canada show increased recognized Indigenous authority over conservation though implementation varies. In Panama, we have seen some advances in the Comarca system. This provides territorial autonomy for Indigenous peoples. And we also see legal personhood for ecosystems such as the Te Urewera in Aotearoa, New Zealand. Aotearoa in New Zealand, and the Wanganui River, which was granted personhood and legal standing, requires Maori guardianship. And so, these alternatives, they should be assessed critically, right? Do they fundamentally shift power relations, or do they accommodate Indigenous governance within existing harmful structures, right? What political, legal, and economic conditions enable some jurisdictions to adopt these models while others resist or others cannot, right? And are these models replicable or context specific, right? I want you to think about some case studies that you're familiar with. And you know, it's important to remember FPIC principles, they should apply to research itself, right? Yet academic structures very often exclude community authority. If communities have the right to consent to development of projects that affect them, right, they should have equivalent rights over research conducted about them, right? But most institutional review boards treat communities as subjects, right, requiring protection but not sovereigns requiring consent. Okay, consider these questions in your own research, right? Who owns the data that you are conducting? Who benefits from the publications you produce? Are research timelines driven by academic requirements or community priorities, right? What reciprocity exists beyond acknowledgement sections, right? And does your research methodology reproduce or challenge the power dynamics you seek to interrogate in your study, right? You have to think about this. It should reflect on these questions. This goes back to positionality, right? It's not just something to focus on in an ethics section, but to think about as you're conducting everything from conception to closing, right? So again, measuring FPIC effectiveness, it requires multiple indicators, okay, because it serves multiple functions. Quantitative metrics include, the percentage of projects halted, legal cases won, land formally demarcated or returned. But again, these are capturing observable outcomes, but they're missing those subtler dimensions, right? Some of those EJ pathways. Qualitative assessments, as we talked about with interviews, they're going to examine self-determination, cultural continuity, governance strengthening. But you may need to bridge these, right? Again, this is the importance of this interdisciplinary, multidisciplinary research, right? A project might proceed with documented consent, yet it might still undermine social cohesion or cultural practices in ways that just the numbers, the quantitative data won't capture, right? Process metrics, they evaluate who participated, how decisions were made, how much time was collected, whether customary decision making was respected, and whether women, youth, and marginalized groups were included. And we're going to talk about monitoring and evaluation frameworks. These are critical variables to have within a justice-centered monitoring and evaluation framework. Outcome metrics, these are going to track environmental quality changes, community well-being, benefit distribution over time. Structural change indicators are going to assess whether power relations shift, like you just did in your previous assignment. Do communities gain greater authority over subsequent decisions? Does capacity for negotiation increase? Do legal frameworks change? And so combining these approaches really provides more complete assessment than just looking at one single metric, right? We want to move away from these, single dimensional approaches that just don't capture the full picture in this type of research. So, I'm going to give you kind of my honest assessment of FPIC, and that it requires, acknowledging the limitations of this, right? FPIC cannot substitute for land restitution, right? Consenting to future uses of land does not address historical land theft and dispossession, right? FPIC operates within existing systems, existing property law systems, existing policies. And these, they may not recognize Indigenous jurisdiction. They may be designed to ignore that, right? They may limit the scope of what communities can consent to or refuse. And also you have to be careful because they can be co-opted as a legitimation mechanism, right? Projects can claim that, hey, we got consent. Consent was obtained, right? And this would make continued opposition appear illegitimate, even when the consent process was flawed. So we have to be careful, right? We have to take, careful steps. Individual community members, again, they may have interests that conflict with collective decisions, right? What do you do in that case? This raises questions about whose consent counts. Intergenerational questions can emerge, right? How can current community members consent to impacts that are going to affect future generations? what happens if communities say yes under economic pressure, and that does not sort of meet the free criterion, right? They are under duress. So again, this is really complicated. We can't go into all of this, but I want you to kind of ruminate on these ideas and think about these in your work and your research and in the future ahead, right? But again, this does not invalidate FPIC as a tool, but it requires this realistic expectation setting about what it really can achieve within the existing structures that we live within. So again, I want you to think about some things. Can FPIC function effectively within capitalist development models that require this continuous resource extraction, or does meaningful FPIC require different economic structures altogether, right? I want you to also think about, how do FPIC principles apply to, diverse environmental issues, but especially, issues where state agencies may have to or may have historically made unilateral decisions about management of an ecosystem, of a wildlife species, of the way waste is zoned or governed, of the way that a drilling site is being placed near a community. And how does that impact, when communities are seeking compensation but don't have authority, right? And I also want you to think about, again, what we just talked about. What do you do when communities are internally divided about resource decisions, right? What do you do when a large portion of the community really wants to have this mine sited nearby because it's going to create jobs, but there's a serious health concern or a concern for, newborn baby health that could impact future generations, right? So again, these are not rhetorical questions. They are analytical challenges, and they're going to really be central to theory and practice in environmental justice and through the application of FPIC. So again, thanks for your time. I really appreciate you engaging with these kind of tough topics. I know this one, was a bit deep and maybe a little bit heady for you, but again, I just want to, reinforce that we're looking to reveal these substantial gaps between these systems that we live and operate within, right? Systemic failures across context doesn't mean that we are ultimately defeated, right? So I just, don't let this get you down. It's not cynicism, but we're doing critical analysis, which is really necessary for these justice-oriented research approaches and practice. And your work really sits at this intersection of, we talk about conservation, community rights, environmental health, organizing, community rights, all of these different things. And the question of who decides on these things, right? These tensions, they don't resolve easily, but recognizing them is, just the starting point for meaningful engagement with environmental justice. So awesome. Thanks so much.